Thank you, Ben, for that very kind introduction and for calling it a brave effort. You should have warned me before that it was a difficult project. I didn't know it when I said yes to the invitation of Detlef. Well, thank you. Thank you for being here, both to my students and to our guests. Also, before I proceed to the big legal stuff, matter of housekeeping, to the two class presidents, please, can you speak to me after class, okay? Okay, having dealt with that. Can we have the first slide, please? I just want to give you a flavor of the approach. Detlef, I got this from a German philosopher, Facts and Norms, but apparently had a more difficult and more precise German term. I think he used facticity and normativity. But you see, the Philippine approach is always to use privacy as a big concept. And our goal here, as I will do in 1 minute, is to situate it in specific contexts. But precisely the difficulty in doing that. So there is an advantage to situating the big concept, the norm, in specific factual contexts. And that is the heart of the case method, which was pioneered by our law school here in the Philippines. But the reverse effect, however, let's proceed to the next, is a case-by-case approach. And that is exactly how Philippine law right now deals with cell phone evidence. And in the course of the research I have conferred with the PNP, in fact, has an office specifically focusing on cell phone evidence, on electronic evidence. They have the technology, they have a foreign training to deal with this. I have also met with the general counsels of SMART and Globe. And really, what is happening right now is the good old Philippine solution. Our law enforcement officers need access. They will speak to SMART and to Globe, and then to monitor the call. And when eventually it is about to be used in court proceedings, that is when the search warrant and the legal requirements will be met. We will go into that detail later. And as I say here, perhaps we should do it the proper legal way, for everybody's sake, but specifically for the purpose of protecting the right to privacy, and also to give assurance to the enforcement officers that if they're doing it a certain way, they are properly covered by law, and that the evidence that they secure will not be excluded later on. And that is why I will focus on three factual episodes. The next slide, please. I will just review for you the episodes. You must be familiar about these in the newspapers. The Garci tapes, the Ampatuan massacre, and the June Lozada kidnapping and attempted disappearance. In all these cases, cell phone evidence will be the key to the debate, and yet there were problems accessing the evidence. Let's proceed to the first, Garci. As you might recall, in 2005, the press secretary, the spokesman of the president, says that there is a CD going around the city containing a conversation between the president and a certain person named Garci, conspiring to cheat in the 2004 presidential elections. There were very interesting episodes. One was the woman's voice, ma'am, I will call her ma'am. Ma'am's voice saying, I want to win by 1 million votes. Garci saying, ma'am, it's just 800 votes right now, but we can find a way. And then the experts later were able to track the increases in the votes for ma'am eventually to meet 1 million. And then the Garci guy is saying, ma'am saying, we're having problems with this election registrar somewhere in Mindanao. And Garci saying, ma'am, don't worry, we have kidnapped the family of the registrar. We will have the results that we want. So that is the kind of conversation that we had. And yet, what was the result? the government warned anyone playing the tapes that they can be arrested, saying that this was a violation of the anti-wiretapping law because that law says that you cannot record and play a tape unless that you got the consent of both parties to the conversation. In fact, despite the warning, we played the tape publicly at UP. You know, I love defying these warnings. Oh, we played it right here in this room. And I think there is a value actually to the playing, because right now we assume that with modern technology, they can make a prohibition all over. But we can watch it anyway, we can listen to it on our computers. But there was an effect there. I noticed that for the first time it was being played, that we were all listening to it in public, and that we were reacting either with outrage, with disgust, or just sheer laughter at certain portions of the conversation. In other words, bringing it into the public sphere contributed to the discourse, to the quality of the discourse. But notice there are two cases which were filed before the court. There were actually three. The first was the impeachment case against President Arroyo. And at that time, the Congress asked for the legal opinion of several people, myself included. And my opinion was this. Of course, there was no consent. And of course, as you will see later with the wording of the anti-wiretapping law, there was a violation. And therefore, under the rules, it's inadmissible in evidence. However, my position was the right to privacy will have to be invoked by the parties. In other words, if Garci says that he did not consent, he should step forward and say so. If ma'am, the woman's voice, presumably Arroyo's, distinctively Arroyo's, says that she did not consent, she should step forward. In other words, in order to block the admissibility of the tapes, in other words, that would be a legal success for them, they should pay the political price. They should confess that they were the ones who were conspiring to cheat in the elections and to kidnap the family of the election registrar. And I submitted that opinion to Congress. Obviously, they didn't listen to my opinion, and they proceeded to dismiss the case against, the impeachment case. I'd like to proceed to the next. This is the Ampatuan massacre. The lawyer in this, the private prosecutor is Professor Harry Roque, my colleague, my former student, my colleague in the faculty. And one key piece of evidence was a flash disk, right? It's called flash disk. Is it? Flash drive, flash disk. The small thing. I have one here. Something like this, which contained evidence against the Ampatuans and the counsel for the defense counsel for Ampatuan, my teammate actually in the Jesup Moot Court competition, Siegfried, objected to the admissibility of the flash disk. Why? Because central to the admissibility is proof of the authenticity of that disk, and the way to do it is to present the person who recorded the evidence on that disk. And of course, since you're trying to prosecute a warlord who can kill anyone, they couldn't find the person who did the recording. And Harry Roque, as a private prosecutor, was able at least to preserve the admissibility of the evidence, not as testimonial evidence, but as real evidence, as a thing, not as a recording. There are disadvantages to having done that, but Harry had to do it. Otherwise, that disc will be, well, it can very well be lost. At least by doing that, it is preserved in the record of the court and will remain under the protection of the court. The other, and this is something that we will have to deal with later, is that the cell phone conversations will record exactly where Datu Andal Ampatuan would be, where Datu Unsay would be located at a given moment. And that is part of the problem that we will deal with later. The use of the cell phone conversation, not really for the content, and this is the fundamental distinction, not for the content of the conversation, but for, again, a term we will deal with in constitutional law over and over again, a content-neutral